Good afternoon, everyone, and welcome back to the Brainy Boomer Lecture Series. We're so very happy that you've all joined us today. In 2007, the McGill University Research Center for Studies in Aging, or the MCSA's Education Committee, started the Brainy Boomer Lecture Series in order to suggest practical steps to both improve and maintain brain health, as well as to promote healthy lifestyle choices amongst the most populous generation in history. The MCSA's Education Committee, which was founded in 1996, has three main objectives: identifying education needs of healthcare providers, seniors, caregivers, and the public, and to develop responses to meet some of those needs; to enhance the positive image of the aging process by addressing stereotypes and myths about aging; and finally, the dissemination of research on aging. The Legal Information Clinic at McGill, or the LICM, is committed to increasing access to justice for McGill and Montreal communities and to meeting the needs of students and marginalized groups because justice matters for everyone. Before continuing, we would like to remind you to please mute your microphone on Zoom, and that if you have any questions, you can wait until the end of the conference, or you could write them down in the chat box on Zoom. And now I'd like to invite Audrey and Katrina to start their presentation, Protection Mandates, Advanced Medical Directives, and Wills.
All right, so hi, we'll just introduce ourselves briefly before we get started. My name is Katrina Graham. I'm a second-year law student at McGill. My background is in anthropology, and I'm also a yoga teacher. Audrey?
So hi, I'm Audrey. I'm also a second-year law student at McGill, and my background is in community organizing. So very happy to be with you this afternoon.
Great. So Audrey is going to start us off, just introducing the presentation. Or actually, no, first, before that, excuse me, I'd like to just make a land acknowledgement. So the LICM is located today on traditional territory of the Kanien'kehá:ka and the Anishinaabe nations, so Indigenous nations. And that was a place, and still is a place, of meeting, exchange amongst Indigenous nations. So we recognize as an organization and respect the Kanien'kehá:ka and Anishinaabe nations as the traditional custodians of the lands and waters in which we meet today. So as Caitlin briefly touched on, we are from the LICM, and in practice, what that means is that we're a legal clinic, right? So anyone, whether you have questions about wills, mandates, or any other civil law question, you can give us a call. You can look us up really easily online, and then one of our volunteer researchers will do research into that legal question that you have and get back to you in just a few days. So that's pretty great. Our agenda for today.
Okay, so today we will examine what protection mandates are and also protective supervision. And we will then look at your different options for creating a will and the advantages and disadvantages of each. And then we'll briefly look at what advanced medical directives are and how to make them. So the presentation will contain a couple of short quizzes, and we will conclude with a period of questions.
So, what are protection mandates? Generally, a mandate is a contractual relationship where someone gives a person of their choice the power to represent them, so in the performance of certain tasks and judicial acts and administration of their property. Mandates are governed by the CCQ, so that's the Quebec Civil Code. And that's the statute that governs the relations between people and property. A protection mandate is a type of mandate where someone of full age and sound mind designates someone that they choose to take care of them and administer their property in the event that they become what the law considers incapacitated. So here, the word incapacity essentially means that the person is unable to take care of themselves, make decisions relating to themselves or their property because of an illness, an accident, or an impairment or other age-related limitation. Examples of when a protection mandate is needed are, for instance, we can imagine a senior person that has recently been diagnosed with Parkinson's. So this person anticipates that soon they will become incapacitated. What they do then is arrange in advance for their care and the administration of their property. This person would prepare a protection mandate when they're still capable of making decisions for themselves. So it's important that this is really a proactive and preventative measure to take. Another example could be an 18-year-old who plans to do some extreme sports, right? They understand that there is a serious danger or risk in the sport, and that they actually also have the capacity or potential, to lose capacity due to an accident. That person could also prepare a protection mandate. But as we all know, 18-year-olds consider themselves invincible and maybe immortal, and so that's pretty rare to see. So who are the parties involved, right? The people involved in a protection mandate. The first is the mandator. So the person who's drafting the protection mandate, the person who's saying to themselves, maybe I'm going to need help in the near future, or maybe even in the far future, depending on what the illness is. And then there's the mandatory, the person who's been chosen to take care of the mandator. The mandatory needs to be an adult. So, and it's also a person that the mandator trusts really well. So to use the example from the last slide, the mandator, might be a senior person with Parkinson's, and the mandatory might be their daughter. So before we move on to the next slide, we'll do just a little scenario, and you don't need to answer out loud or anything. You can if you want, but we'll just kind of quiz you to see if you understand which is which of the jargon, because we're going to be saying the two words over and over again. And if you're mixing them up, that's not really too helpful. So we can imagine that I decide to quit law school and embrace my career as a stunt woman. And although I know that there are lots of risks involved with full-time stunting, I decide to do it anyway and just enter into a protection mandate with Audrey, who will then maybe take care of me in the event that I become incapacitated. So in this scenario, whether you type it into the chat or you just think it or say it out loud to yourself, Audrey would become the what? The mandator or the mandatory. And I would be the what? Mandator or mandatory. So Audrey is the one taking care of me, so she's the mandatory. I'm the one writing up this protection mandate in advance. I'm the mandator. So what does a mandatory have to do? What are their responsibilities? Mandatory must fulfill their mandate with prudence and diligence. They must do so faithfully and honestly, and always with the best interest of the mandator at heart or in mind. Okay? They shall also avoid placing themselves in a position where their personal interests are in conflict with that of their mandator. So for instance, you wouldn't be making a decision, an economic decision or a property decision about, that you have now the power to take or make, that would really just be in your best interest. For instance, encouraging someone to leave you something in their will, like these kinds of abuses. And that's the kind of thing that is definitely not allowed and could be signaled to the court. A mandatory is also responsible for fulfilling the mandate that they agreed to. So this means that they cannot just back out at any moment. Unless the mandator gives them authorization to appoint another person, the mandatory is really held in law responsible to fulfill the protection mandate. Depending on the role that someone gives their mandatory, their responsibilities might include things like making decisions just regarding housing situations, ensuring basic needs like clothing, personal hygiene are taken care of, or even healthcare, housing issues, paying bills, like anything that you could imagine that someone might need help dealing with. So all of that would be clearly stated out in this protection mandate, which is kind of like a little contract. The mandatory is also only only responsible for things that are really set out in the mandate. So just because generally people give power to the mandatory to do the payment of certain bills, maybe that's not what's in this protection mandate. Okay, so they can't just go off script and do whatever they want just because they think it's in the best interest of the mandator. So when is a protection mandate made? Okay. The protection mandate must be made under the circumstances where the mandator is in full capacity to consent to the contractual agreement that they're entering into, right? It's not far into one's maybe cognitive illness or after an accident that a protection mandate can be made. It's before. This means that the mandate must be either notarized, okay, so signed in front of a notary, or written up and signed in front of 2 witnesses. Okay, so for it to be legal and for it to be then enforced once the person is no longer once the person is incapacitated, it needs to be either notarized or signed in front of 2 witnesses. And again, just a little reminder of what capacity means. In this situation, capacity means that the mandator is able to comfortably express their wishes and declare that they understand the consequences of the decisions that they're making. Okay, so if at any time someone wants to refute this, right, one member, one person that's close to the mandator thinks that they're not actually in sound mind to be signing, that could be something that happens, right? Someone says, you know what, maybe this isn't right. This person maybe doesn't have full capacity to make that kind of decision and sign away that kind of agency. So someone could, say, you know what, maybe that's not appropriate. When does it come into effect, right? Like I said, it's something that happens proactively. Just because you've signed it doesn't mean it's actually working, doesn't mean that as soon as you sign it, the person that you've given power to now has that power. It's later. So the protection mandate will only come into effect once 2 things occur. 1, the mandator, like I said, has become incapacitated. And second, that the mandate has been homologated by a judge. So homologation is basically just a judgment of the court that approves the execution of an act. So in the context of protection mandates, this means that when the mandator becomes incapacitated, the court must render a judgment that makes that mandate official. And that's when things like whether the person was really able to consent, whether the scope, right, the clauses in this mandate are too broad or unfair, or maybe that the person that's being chosen as the mandatory isn't the right person. So the judge is going to really look at all of these factors and decide whether or not they should give this contract the force of law. The homologation proceeding is essentially for the purpose of making sure that the person really is incapacitated and making sure that the contract is in the best interest of that person. It's important to recognize that getting the contract or the protection mandate, homologated is crucial. Without that, it's not valid. Okay. Again, just a little quiz. We didn't make a slide for it this time, but what are the 2 things that need to happen before a protection mandate can come into force? You can write in the chat, you can think about it, you can say it out loud. 2 things need to happen. One of them has to do with the mandator, and the other thing has to do with a court. So before the protection mandate comes into force, the mandator must be incapacitated, and the protection mandate must be homologated, so rendered in force by a judge. Next, when is the mandate terminated, right? Because sometimes we have illnesses that don't last forever, right? Sometimes you have an accident where you need help for a certain period of time and then you don't later. right? So the mandate can cease to have effect when a court ascertains that the mandator has become, again, capable, right? So that's something that they can do. They can go to the court and be like, hey, I'm fine. I'm of sound mind now. I do not need the mandatory to be making these decisions for me anymore. Alternatively, if the mandator becomes fully capable of making decisions again, like I said, they're in legal jargon, they're unilaterally allowed to revoke the protection mandate. That means they don't have to get the consent of the mandatory to decide that the protection mandate is no longer in force. They can do that on their own. The mandatory, the person who administers and manages the well-being and property of the mandatator, may also unilaterally renunciate the mandate if they notify the mandator. However, if they renounce without a serious reason or at an inopportune moment, they might be bound to make reparations for any injury caused to the mandator by their renunciation. So if someone has been given that role, that power to take care of the mandator, and they just decide on the flip of the hat, they're too busy or for some other reason that they're not going to do it, they might actually be held responsible economically for making reparations and compensating the mandator for anything that can happen to them while they're no longer fulfilling their duties. And then again, a protection mandate, just like any contract, can be terminated where the contract is breached. So similar to what I was just talking about, if they're not doing the things that they're supposed to do, whether the mandator or maybe someone that's talking on their behalf might go to a court and say, you know what, this mandatory is not actually fulfilling their job, they're not doing it, and so then the protection mandate could be annulled. And then the last and more obvious is the death of either party, right? Whether the mandator or the mandatory, someone passes away, obviously the contract no longer exists. Modifying the mandate, right? It's an important question because sometimes we write up a contract, we think this is what we're going to want, or this is the person we're going to want, this is the things that we're going to want them to take care of in the future, and we change our mind. So as long as the mandator, the person writing up the protection mandate for themselves, is still has capacity, they are able to change any clause, any decision that they've made in that contract. This has to be done again, though, at this, back with a notary or in front of those two witnesses. So everything that you change, you have to go back before a notary. Okay? And then obviously the most recent version of the protection mandate will be the one that's enforced. However, if the mandator is incapacitated, there are still situations where the protection mandate can be changed. In the contents of the if the contents, for instance, of the protection mandate are unclear, or if they're unclear, then with the permission of the court, the mandatory may obtain consent or authorization to change the contents of the mandate. If it says, make sure I'm happy, or something vague like that, you're going to have to go in front of a court and then make sure that things are put in a really literal and understandable and enforceable way, because one of the responsibilities of the mandatory is to really strictly adhere to that protection mandate. If it's written in a vague way, they can't do that job. If the mandatory is not executing his or her duties according to what was set out in the mandate, the court can also decide to remove the mandatory. And that's decided on a case-by-case basis. So again, it could be someone else that's close to the mandator, or the public curator, which is a state official in charge of these situations. So they're a person that you could go to. They're kind of like an ombudsman for the mandator, making sure, oh, that's a big word. It's kind of like a person that's looking over the mandator, making sure that they're safe and that everything is, all the actions being taken are in their best interest. If there's no protection mandate. So if there's no protection mandate, protection supervision will typically come into play, where the protection mandate is either inexistent or it's deemed void or too vague, or maybe void for reasons like the person was already incapacitated and couldn't properly consent. Okay? In order to fall under protective supervision, a court must render a judgment to that effect. So similar to the protective mandate, a court needs to be involved before these kinds of transfer of agency and autonomy can happen. As a general rule, the protective supervision can be requested by any person who shows that they have a special interest in the incapacitated person. So this means anyone that's worried about their health, security, and proper management of their property can request a protective supervision. The request could therefore be made by a spouse, a partner, close relative, a friend, or anyone who helps support the person, as long as the person is really looking out for their best interests and it's someone that the mandator trusts. And then again, I'll just reiterate, it's important to be proactive, right? So if anyone feels that they are losing their capacity, or they've, imagine in the future that they might, it's really important to think of drafting a protective mandate before it's too late, because then we end up in situations where we use protective supervision instead. Okay. We'll do one last true or false before Audrey takes it away. Okay, so can anyone ask to have a protective supervision for someone else? So, for instance, can your mailman, actually, that could actually work. Can anyone ask for a protective supervision of a person? Technically, it's almost yes, right? It's the one caveat is that they have to be looking out for the best interest and care about that person, right? They have to have enough of a factual tie. That's why my mailman example isn't really too good, because maybe the mailman does meet this person on a daily basis and they have seen that they lose capacity over time. But it has to be someone that can prove that they know the person well and that they're really acting in their best interest. Anyone who cares and supports about someone can ask for a protective supervision. Audrey, take it away.
Yeah, so I'll take on from now. So there are 3 types of protective supervision, and I'll briefly go over them. So the first one is the advisor. So a court may appoint an advisor to a person who is not totally incapacitated and who, although generally capable of caring for themselves and needs for certain acts or for a certain time, to be assisted in the administration of their property. So this option, so the advisor option, gives the most freedom to the person being supervised. So this person is advised, and the sort of advice of the advisor are not legally binding. So the second type of protective supervision is the tutorship. So a person may become partially or temporarily incapacitated, which means that this person can still take care from themselves and make decisions on their own, but to a more limited extent. So a court may then appoint a tutor to this person who needs representation in the exercise of their civil rights. So note that unlike an advisor, the tutor can actually administer the property of the person and is not just advising them. And also note that if the incapacitated person is under 18, tutorship is the only protective supervision option that is allowed. So I think that a helpful comparison that I've read is that the tutorship supervision is kind of similar to the supervision upon a child or upon a teenager, where they have autonomy, but there are certain legal acts that it cannot perform by themselves. And the last type of protective supervision is the curatorship. So a court may institute a curatorship when an individual is completely and permanently incapacitated and needs to be represented in the exercise of their civil rights. So the curator appointed by the court will have the full power to care for the person and administer their property, except otherwise indicated by the court. And obviously, this option has the least freedom for the person being supervised. So, oh, I think we just did this one. Yeah. So I will now talk briefly about wills. So if you can go to the next slide. Okay, so I'll first talk about who can make a will. So to make a will, a person must be 18 years old and of sound mind, which, like Katrina explained, means that the person understands the nature of the document and its consequences. So there are a lot of good reasons to make a will. So if somebody passes away without a will, standard legal rules will apply. And here are some examples. So if you never formally divorce your ex-spouse, that person has a right to inherit and will get part of your property. And if a person has a partner but is not married to this partner, well, the partner will not have a right to anything. So some people's marriage contracts include some statements about who should inherit one's property. However, these statements are often not as complete as a will would be. And if you're unsure about like whether or not you need a will, it's always a good idea to consult a notary. So that person can tell you if your marriage contract reflects your true wishes given your situation. So there are three types of will, which I will briefly cover. So the first one is the notarial will. So notarial wills, like the name indicates, are written by a notary. So a notarial will must be written in English or French and must indicate the place and date it was made. So it must be signed before the notary and a witness. And sometimes two witnesses are necessary, but you don't usually have to worry about getting a witness because the notary takes care of this. So one advantage of a notarial will is they are harder to challenge. And this is because the notary has made sure of your identity and that you agreed to the will. So the notary also makes sure the will follows all the applicable legal rules. And they are also easy to find after somebody passes, as the notary keeps it in an official registry. Although a disadvantage is that obviously you have to pay a fee for the notary, and the costs are usually between like $200 and $500 for making such a will. So the second type of will I'm going to be talking about is the will in the presence of witnesses. So you can also create a will by writing one and then signing it in the presence of two witnesses. So anyone 18 or older can be a witness, but a person who will benefit from the will cannot be a witness. And also, please note that a will prepared by a lawyer is considered to be a will made in the presence of two witnesses. So the biggest advantage of this type of will is that it can be free unless you choose to use a lawyer. And a disadvantage of this type of will is that it must be probated after somebody passes away. So to probate means to make official by a notary or by the court. And this involves cost and takes time. And we're talking like months here. So the probate fees are usually around $1,500. And obviously another disadvantage is that these kinds of wills can also be lost, destroyed, or damaged. So the last type of will I'm going to talk about is the holograph will. So a holograph will only has two requirements. So the first one is it must be written by hand, and that means not on a computer or using any other mechanical means. And secondly, it must be signed by the person making the will. So even if you don't need witnesses of this kind for this kind of will, it's a good idea to tell your loved ones like where you plan to keep it. And the advantage of this type of will is that it can be made anywhere, anytime, and for free. Although a disadvantage of this type of will is that, like a will made in the presence of witnesses, it must be probated. So this involves costs and delays, and those type of will obviously can also be lost, destroyed, or damaged. So yeah, if one is wondering, will my will be respected? Well, it's important to know that for the most part, everything in a will be respected. However, last wishes must make sense and not go against public order. So I'll give you some examples. So if a clause in a will cannot be enforced, if the person benefiting refuses the gift, or if the beneficiary, which is the person receiving a gift, has died before the testator, which is the person who will will. Obviously, if a piece of property no longer exists, it cannot be given to anyone, and the heir will not get money instead. A person making a will cannot give something that does not belong to themselves, obviously. And if a gift comes with an impossible or illegal condition, so if that person does this, I'll give her that, well, that condition is canceled. It has to be legal, it has to be possible. So I will now proceed to a little quiz, which is a true or false. So let's say that Andrea is leaving most of her belongings to her son, James. James and his partner, Alex, can act as the two witnesses for her will. Is this true or is this false? So in this case, it would be false because James is benefiting from the will and so he cannot act as a witness. Okay, so that was it for the will, and I will move on to our last subject for today, which is advanced medical directives. So this is another way to plan ahead to make an advanced medical directives. So the advanced medical directive lets you mention ahead of time whether you accept or refuse certain types of healthcare. So medical staff must refer to this document and respect your wishes if you can't make your own decisions about treatment. So if the wishes expressed in the medical directives contradict what is said in a protection mandate, then the directives surpass the mandate and will be followed. So in advanced medical directives, you can only say you accept or refuse certain categories of treatments. So there are 5, and they are the CPR, so restarting the heart and breathing, the use of a ventilator, so which is a machine to assist in breathing, the dialysis, which keeps the kidneys functioning, force feeding and hydration, so feeding or giving liquids against the patient's will, and artificial feeding and hydration, which is, for example, using a tub when someone can't eat or drink in a more normal way. So these are the only treatments that medical directives can concern. So there are 2 ways to make advanced medical directives. The first one is with a notary, and the second one is using a free government form that you sign in front of witnesses. So this form can be found on the HAMQ website along with instructions. So I will now conclude with our very last quiz. So true or false, you can make advanced medical directives for free in Quebec by submitting a form to HAMQ. So yeah, this is true. Well done. So
Okay, thank you so much, Katrina and Audrey, for that fantastic presentation. We would like to thank you and everybody else who showed up today. We have, as usual, all of our information, all of our links, I should say, down in the chat box. So we have the link to our Eventbrite page in case you would like to check out our upcoming events. We did put up some new ones. We have the link to a brief survey. We would love to hear your feedback about today's event or any other event, Brainy Boomer event that you've attended. We have the link to our YouTube page in case you would like to go back and get some more information about today's event, or again, any other event that you've attended. We also have the link if you would like to get some more information about MCSA, or maybe you would like to make a donation. We also have that link down in our chat box. So just one more time, thank you so much for coming today and have a great day, everyone.